Please be seated, everybody. Good afternoon.
Good afternoon.
We're here on the motion of Mr. Butler withdraw. Mr. Campion, are you on the phone?
I am here, thank you.
Very good. Is Miss Mowdy on the phone as well?
No, she didn't.
Okay, Miss Mowdy is not on the phone. I have, during the course of this matter, we've taken longer than I would normally take. I have expressed at the last hearing that was public my displeasure with this, the impact on the victims, the impact on the state, the court system, and on Ms. James. Also expressed my disappointment that this happened. During the interim, since I issued an order, and I asked that independent counsel be appointed for Ms. James. The appointment was made, the meeting was had, I had a ex parte in-camera hearing with Ms. James and the lawyer who advised her on her right to either withdraw or consent to withdraw or not consent to withdraw. We held it ex parte because we went into the legal advice given Ms. James. At that time, Ms. James reaffirmed to the court her consent to Mr. Butler's withdrawal. Has anything changed, Ms. James?
I need a new lawyer, yes.
No?
I need a new lawyer. Yes, I do need a new lawyer.
Do you consent to Mr. Butler withdrawing from your case still?
The situation's not going to work. I need a new lawyer.
Let me be as articulate as I can. You need a new lawyer. Mr. Butler apparently thinks you're out of funds. He wants to withdraw.
Yes.
The difference to me is whether you consent to his withdrawal or don't consent to his withdrawal. If you want a new lawyer, we got to go in through that discussion.
I can't afford to pay him.
So you then consent to his withdrawal.
If that's my option, yeah. Only option, yeah.
Well, it's not your only option. You could say, Judge, I don't consent to his withdrawal. I paid him $100,000 and I think he ought to finish the case. You could tell me that.
And at this point, I don't think that trying to push that situation is going to work. I think at this point it's better for to allow him to withdraw.
Okay. These are findings I'm going to make. I did have, as I said, a in-camera discussion with Ms. James and her counsel. At that point, she, when I inquired and she had her counsel there, told me she did consent to the withdrawal of Mr. Butler. She gave me the reasons that she consented, and I believe nothing has changed. With the consent of Ms. James, I could still would have the discretion of not relieving Mr. Butler from his obligations. However, because of the reasons Ms. James gave me, in order to be fair to her and to allow her to have an attorney who she feels will effectively and actively represent her, I will relieve Mr. Butler. I will require Mr. Butler and his staff to be available to anybody who substitutes in. I want to make the following findings. I find there's no fee agreement that was provided as required by the professional rules. I am now trying to determine whether this is a mandatory report by me, that I must report this to the Bar Association, or it's discretionary. If it's mandatory, obviously I will appoint it. If it's I will report it. If it's discretionary, I may still report it. I'm disappointed, Mr. Butler. The legal profession is more than just a business to extract money. You have you had an obligation to Ms. James. You spent her fees. You filed some motions for production. You filed, I thought, a good motion to dismiss, but Ms. James, my counsel to you, ma'am, to you, is to talk to somebody about filing a complaint with the Bar Association and asking for a portion of the fees back as money that you got no benefit from, or very little benefit. It's up to you. I'm not going to order that. I will relieve Mr. Butler with Ms. James' consent. I will appoint, Mr. Vandermark is here. The Public Defender's Office had a conflict, so I will appoint OPA to represent Ms. James. Mr. Vandermark, are you going to be counsel of record, or should she?
I have no idea. Right now our caseloads are running at about 30, 35 days in unclassified. I have to decide whose caseload it goes into. That person will probably quit. So I don't know.
At the end of this hearing, would you do me a favor, talk to Ms. James, tell her who to, give her your number, who to
Yeah, I
phone?
will.
Okay, I appreciate it. Thank you very much. We'll be in recess.
Is there a date we come back?
Let's get a date. What we'll need is a new pretrial hearing. Let's put it 30 days out. I want to give the new lawyer an opportunity to talk with Ms. James. June 17th at 3:30. Thank you very much.
For the record, Judge, I want the record to reflect that I object to a couple of the court's findings. First of all, as it relates to the work done in the case, there's a lot of work that was not billed against the file, and Ms. James is also aware of that. And we gave, for the record, many discounts. Work that a lawyer could have done at a lawyer's rate was done by Julie Edwards, a lot of it, to save money on the case. And as I said before, there are a number of things not even billed. I think even hearings that we had that weren't even billed, work that I've done. Nothing that's a lot of the paperwork in the file that I've reviewed, because I don't believe in double billing. I try not to. The motions and things that I reviewed and finalized and signed, I don't sign anything coming out of office without reviewing it, editing it, modifying it, or whatever the case may be, and everyone in my office knows that. So for the court to make it appear that somehow there's been a robbery in the case is troubling, because the court doesn't have all the facts that we have. We requested an ex parte hearing and never got one from the court. I noticed that the Public Defender Agency did get one. And so I am troubled by that, because I think that had we had an ex parte hearing, more information would have, we could have given to the court for the court to make the findings that have been made. But I was not, and still am not, prepared to put on a public record information that I think may hurt or not be beneficial to my client in the long run. This is a public record, and it has to be treated as such, and the court's findings on the public record are troublesome.
Okay. They were meant to be troubling, Mr. Butler. I would have taken this case for $100,000. I would have thrown in an appeal if that was necessary. That's all I'm telling you. I've done box law before. I've gone through boxes of OCS documents. I'm not saying you didn't fairly earn the bills you sent out and the money you extracted. I'm just saying there's something missing. That's all I'm saying.
There are 12 to 13 bankers boxes here. 12 or 13 bankers boxes.
Right, and you know what? I go through those on a weekend with some regularity. I go through those banker boxes of OCS documents, most of which are duplicates. I mark which ones are important, what I need for my case in chief, what I need for cross-examination. So you just got to do it. You got to plow through those boxes.
Judge,
just do it.
This is the thing about what you're saying, and there's a couple of things here. Number one is this: when you're representing an individual and they have facing a lot of jail time, you can't just give these documents cursory review. You have to know practically everything that's in the file. You got to cross-reference a lot of materials, and we have to keep in mind that the court did the initial in-camera review here and gave us, I think, one box when there was multiple stuff that needed to be turned over to us. And so if you go through this stuff too quickly, you're going to miss something, and we don't have that luxury. I do not want the luxury on my conscience that there was a smoking gun in the materials, and we didn't go through it. And quite frankly, not only the motion to dismiss on the kidnapping counts, but there's a lot of work already done on the motion to dismiss the assault counts, waiting primarily on the 35,000 additional pages of discovery so that we can make sure that all of the things throughout those pages can be used in the motion to dismiss the assault count. So the fact of the matter is while the court wants to say, oh, this is troubling and make it troubling and that the practice of law is more than just a business, we do a lot of pro bono work in my office that we never publicize, okay? There's been a fair amount that's been done time and again. But at the same time, you got to recognize when a case is so complicated and so deep that it's going to take more and more money. This case needs an expert witness yet. And we've done some work in terms of identifying one who is reputable and would support the parenting style that she's done in this case. So this case is not just a simple attorney time case. But I am disappointed that the court would come out with these kinds of findings. I have continue to do a lot of things. We just don't brag about it. We just don't put it out in the public. And for the court to make it sound like my office is just, oh, you're looking at clients, it's just a business. Do you think for 1 minute that many of the people that we come in here and represent are all paying their fees?
Well, do you want to continue to represent Ms. James? Is that what you're telling me? It's not just a business? You want to represent her through trial?
If we could afford it, we would have done it.
So the answer is no.
No.
She's not going to be one of your pro bono cases.
Let me tell you this.
Okay.
As I said before, we requested an ex parte hearing. You see, we did request it more than once. You see, never got that from this court, and that to me is routine. What did you want an ex parte hearing for? Well,
you wanted me to see if she qualified for public counsel. And I said we're putting the cart before the horse.
No, the fact of the matter is that it's my understanding that in cases like this, an ex parte hearing is routine.
For what?
Well, that's what ex parte
just to have one or what?
That's what ex parte hearings are for. Okay. With the client, not without the client, with the client, but without a public record and without the other people who are against my client sitting here gawking and what have you, and trying to get information that they can try to later use against her.
Okay.
So
I appreciate it, and I wanted to give. I think it's important you had an opportunity, Mr. Butler. I appreciate it. You put your views on the record. I put mine. That's where we are.
And I would just say this too, that I don't think there's any judge in this system that can say that when I come to court to do a trial, I don't come prepared. You can't come prepared by just simply a cursory view of the police reports and the discovery in the case. And of course, I'm very disappointed at your view of me. And I think that what we probably should do is I shouldn't even.
In this case, you took $100,000 of her money and you withdrawn. That's my view.
I shouldn't do any trials in your courtroom because of your view of me.
No. My view of, okay, if that's what you want to do, Mr. Butler, my view is you are a very good lawyer.
No.
That is my view of you.
No. When a lawyer's credibility is ruined in a court with a judge, as mine is here with you, there's no way that me or my clients can get a fair shake out of you. That's just this clear. That's what
then you either preempt it or make a motion to recuse me. I apologize because
okay. Well, that's what you said.
It's up to you. It's up to you. I think
no,
you're
it was
a fine
up to you,
lawyer.
sir.
I am distressed with your action in this case.
Okay.
And I'm not saying you didn't earn every nickel. I'm just distressed. Thank you very much for being with us.
Please rise and stand in recess.